17-06-1953. The defendant is present, represented by counsels Mr. Riley, Mr. Gorman. On behalf of the state is Prosecutor Lipinzi and D'Angelo. The jury is here, ready to start. Today is Monday, August 30th. Our first order of business will be jury instructions regarding the jury view, and then upon their return, we will complete opening statements. Mr. Riley.
Your Honor, good morning, ma'am. Please the court, Scott Riley, on behalf of Stanley Ford with Attorney Joe Gorman. At this time, we're going to renew all prior motions, including but not limited to our motion for severance and our opposition to the joinder of these matters.
All right, those motions are overruled. We, for the record, I've gone through, and out of the 18, 14 or 16 are vaccinated, 2 are unvaccinated. So, pursuant to the current order in place, there's a mask mandate by the Summit County Executive's Office. I am going to indicate that everyone should be wearing their masks when not talking, but the attorneys, whenever you're talking, may remove your masks. I'll indicate, and again, we'll take a picture I'll take a picture when you all leave, and we'll print it off and make it a court's exhibit, that there are individual barriers between each juror. There's also barriers then between the jury box and counsel table. Witnesses will wear their masks upon entering the courtroom, but once seated, then will remove their masks. Pursuant to, I think, the motion that Mr. Gorman's about to make, that we talked about on Friday regarding the confrontation clause and what you think's appropriate. And the attorneys will be able to then, while they're either doing openings or questioning, they can remove their masks. Now, Mr. Ford may choose to remove his mask and have it off at all times because he's the defendant, and I think it's appropriate if he wants it off. Or he may choose, if he wants to, wear a shield. That's up to him. But I will not mandate that he wear a mask for the purpose that he is the accused. And if he wants to have it off because he thinks it's a disadvantage to have it on, I will permit him to do so. Otherwise, because he's vaccinated. So those are where I am parameter-wise regarding the current state of Summit County's mask mandate. Mr. Gorman.
Thank you, Judge. Judge, so, well, first of all, Judge, I thought I heard you say 14 and 2. Is it 16?
I'm sorry, yes.
Okay, I'm sorry. So,
everyone's vaccinated except for 2.
So 16 are, 2 are.
Correct.
Judge, in discussing this matter with Mr. Riley, and proceeding forward during the pandemic, we've done so with the idea, Judge, that we would be able to see the faces of witnesses. I think the court's assuring us that we're going to be able to do that.
Yes.
And we, for the record, Judge, were able to see the faces of the jurors as we did one here. So that wasn't an issue for us. The only thing I would bring up right now, Judge, is because this is a death penalty case, because the Supreme Court has mandated that the 2 death penalty qualified attorneys defend Mr. Ford, Attorney Riley and I, if it becomes difficult, Judge, we will let you know about communication between the 2 of us if we're sitting at a counsel table without able and having a difficult time communicating. We are both vaccinated, Judge, and both of us have been discussing and are willing to take that risk.
Okay, I appreciate it. Thank you.
Yes, that is correct.
All right.
My understanding is that there's 6 feet between the witness and anybody, so they would be.
I believe so. Not to mention the barriers from the witness box to the jury box.
But I'm just talking about they're the one talking, and there's nobody within 6 feet of them.
Right.
And Judge, without that, we would have, without those parameters put in place, we would be in a different position as far as moving forward.
So the United States Constitution as well as the Ohio Constitution allow for confrontation of your accusers and or witnesses who are subject to cross-examination. I believe in this courtroom at this time that by wearing a mask, the defendant's right to cross-examine and confront his accusers would be diminished if the witnesses were to wear masks. I also believe and find that the county executive's order does not supersede the constitutions of both the United States and the state of Ohio. And while I understand that there are, those are done for security purposes and health purposes to protect those who are unvaccinated. I believe we have taken appropriate precautions throughout this whole process, including and not limited to what is going on in the courtroom from today forward. And I am more than happy to revisit any issues regarding masks as they arise. I'm also going to, there's a couple that indicated they were vaccinated. I don't know if we've gotten their vaccine, copies of their vaccine cards, but the other issue is I believe the FDA is about to make final approval or already has, and that may encourage others to then, now that it's been fully vetted, get the vaccine. And I'll just encourage that if anybody does end up getting vaccinated who hasn't been vaccinated, I encourage them to provide us their vaccine card.
I can tell you, Judge, that Pfizer has clearly already been approved by the FDA. I don't know about the Moderna.
Okay. So that's where we're at, and I'll just, we'll just figure it out as we go. But that's where I'm at right now regarding masks.
And it's just because we've had so many conversations off the record, in between things, and I'm not sure, but I believe regarding masks and vaccinations, because I believe that the court has now complied with all requests by defense in regards to unmasked individuals during voir dire, during testimony, things of that nature. So I believe that's all been accommodated.
Yes, and I do think that Friday when we started general voir dire, I placed on the record everything that the court had done up to that point, as well as what we intended on doing during general voir dire. Any disagreement with Mr. Gorman? Or do you agree with that recitation that we?
I agree with what the prosecutor just said, Judge. But last year when we filed a motion for mistrial, a lot had to do with the requirement of being masked and unable to communicate, unable to confront. The confrontation clause was a huge issue. As we got into this trial, Judge, we made it clear to the state that we would, before the jury was sworn in, be asking for a continuance. During the trial, we would be asking for a mistrial. We still obviously reserve the right to do that if the conditions become such that we don't believe our clients are receiving a fair trial.
Thank you. All righty. Anything else for the record before we start? Bring the jury in.
All rise, please.
No, they're ordered. We should have them by tomorrow.
Okay, Mr. Carter is arrested right now. Mr. Carter, you take the top row all the way down. Ms. Chisnar, Ms. Ford. Ms. Fielder, Ms. Ford, Ms. Fielder, Ms. Ricalla, Ms. Irwin, Mr. Bethel. First row all the way down. Mr. Lovelace. Schweitzer. Ms. Richard. Leslie Ritchie. Ms. Young. Summit County Court of Common Pleas. So now it's the Honorable Christine Croce presiding.
Thank you. You may be seated. Good morning, ladies and gentlemen. Thank you for returning. We are now at that stage where we're going to proceed with the trial portion. As we've explained to you on a number of occasions. Your first thing will be to attend a jury view. Mr. Masich will give you those instructions, but I'm going to read you some general instructions regarding your conduct during that jury view. Upon your return, we will then proceed with opening statements, and as I indicated to you, I believe on Friday, we're going to adjourn today after that, and then first thing tomorrow at 9 a.m. we'll begin with testimony. So remember the admonition that I've given you, and by a show of hands, everybody comply with my admonition over the weekend? Excellent. All 18 have raised their hands. So remember that admonition as you proceed throughout these proceedings here today. It is important you will be given pads of paper when you return regarding taking of notes that you may take today during opening statements. You're not required to. And then tomorrow if you choose to once testimony begins. With regards to masks, as you can see, you're each divided. If that becomes an issue, they're movable. The ones in front will remain at all times, but the individuals, if you feel that that's too much, and you're comfortable and you have conversations with your next door neighbor, I'm okay with removing them. But there is a mask mandate in place. And so we talked about it when we talked to you individually during voir dire. It was important to have that face-to-face communication. Now as it is, you will no longer be talking to anybody. You'll be listening, and the witnesses, of course, will have their masks off. And as I indicated to you, I think on more than one occasion, those of us who are participating have been vaccinated. And so when the attorneys are talking or questioning witnesses or doing opening statements, they will not be wearing masks. At all other times, they will be, unless it's not possible for them to be able to communicate between themselves. And then I will be wearing mine when I'm not talking, okay? So I want you to know that we're taking that mandate serious, but there are considerations in a trial that it's important that you be able to see the witnesses because you're judging their credibility and you're listening to their testimony. You'll be taken to the location involved in this case. You will remain together under the supervision of my bailiff, Mr. Masich, as well as our Chief Executive Officer of the court, Bob Gaynor, because you'll be in two separate buses, and we did this to allow you all to spread out and not necessarily be packed into one bus. Until you return to the courtroom, you'll be under their supervision. Counsel and the defendant may accompany you, but they may not discuss this case or demonstrate anything relating to it to you. The bailiff, Mr. Masich, may call your attention to certain locations or objects that have been requested by counsel. You are not permitted to take your cell phones, so you'll leave your cell phones here. Mr. Masich will lock them up, and they'll be returned to you later today. Or any other electronic communication device or camera with you while on the jury view. You will leave all such devices again with Mr. Masich before you depart. They will be kept in a secure location. Once you observe outside the courtroom, what you observe outside the courtroom is not evidence. Conditions may have changed since the time of the events in this case. The evidence of the physical appearance of the scene must come to you from the witness stand. The only purpose of your visit today is to help you understand the evidence as it is presented here in the courtroom. So with that, we're going to adjourn. You'll go back into the courtroom. Mr. Masich and Mr. Gaynor will then take you down to the buses, and you'll be transported. Ladies, you can take your purses if you want to. If not, we can lock them in that room. I'll be here the whole time, so no one's going to be coming and going. But everybody must leave their cell phones here or any other electronic device here with the court. All right, we're adjourned.
All rise, please.